Welcome to the Ask the Experts show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, welcome to another Ask the Experts. This is the first Thursday of the month. That means our biggest show each month. By far, the most callers that call in. It's our community association show, and our expert is K. Bender Rimbaum, and we always have with us board-certified attorney Robert Kay. Hello, Robert. Okay, there he is. I was just complimenting you.
You were. Thank you.
You're board certified.
Yes,
You're
sir.
a senior partner and one of the finest community association law firms in Florida. And
Thank
I
you.
was just telling everybody, this is without a doubt our most popular show. We're on every Monday and Thursday from 6 to 7. And like I said, this is without a doubt, we get the most phones are already ringing already. But let me say hi to Robert. And Robert, tell everybody about K. Bender Rimbaum first.
Sure. Well, as you aptly put, K. Bender Rimbaum is a firm that provides services to community associations throughout Florida in offices in Pompano Beach, Palm Beach Gardens, and Tampa, covering all aspects of community association operations, interpreting covenants, providing advice to the board on what they can and cannot or should not be doing, interpreting the statutes for them, providing assistance in addressing issues internally, covenant enforcements, collection of assessments, assisting with contract negotiations with vendors, dealing with disputes with vendors, construction defects, insurance issues, pretty much across the board, everything that the board is going to deal with on a day-to-day basis. We provide the legal assistance to that end.
And you have offices both Pompano and in Palm Beach and Tampa.
That's right.
So if you're tuning in for the first time, we do a combination of live call-ins and we do your emails. We get about 30 to 40 emails a month, and Robert decides which ones we're going to be able to get on the air. But as always, let's go to our first caller, Judy in Tamarack. Hi, Judy.
Hi. I thank you for taking my call.
Well, you're going to get a bill.
Board. Pardon me?
You're going to get a bill for this.
Well,
I'm kidding.
I've been racking them up anyway. Our board has been making decisions, taking actions either in violation of our bylaws or in total disregard of them. A group of us have become so concerned that we sent a letter to the management company, which is Ambassador. I don't know if you've ever heard of it. But they totally disregarded our letter and actually sent copies to the board, did not answer us. I ran off copies of the letter, and we've passed it out to the 121 households in our section. And I was wondering, if we get no answer, where do we go from here?
You say you're in a condominium or an HOA?
No. This is a homeowners association.
Okay.
It's a community of homeowners.
And what type of violations do you think are happening?
Well, for one thing, they are spending heaps of money that they have not gone to the community to get permission to spend.
Such as?
That's one thing. Then also we had an election in December, and suddenly we found out that even though the minutes had stated who had been elected, the current board is made up of people different from even those who were in being nominated. I don't know. There was some flap among the board members, and they, on their own, reconstituted themselves without informing the community. Let me see. Then there was an issue at our annual meeting regarding the maintenance, and one of the members at the meeting, it was a Zoom meeting, had a proposal to take a different, to pay a different price from the one that was on that the board had come up with, and the vote was in favor of that proposal. They completely ignored it, and they went back to their own decision as to how much should be collected monthly. I mean, that's just a couple of examples of the fact that they are totally disregarding what exactly the bylaws demand. They set up a finance committee, and we do not have anything in our documents that say that there is a finance committee. And let's see, they want to change the bylaws. I mean, this has been going on for a long time. And they evidently sent it to the lawyer that they used, Tripp Scott, without even consulting the community as to the fact that they are changing the bylaws, and no one has seen it in the community. Then, according to our bylaws, they are supposed to announce when they're having meetings. There's supposed to be a sign-up. They're supposed to send out some sort of notification. That has not been done. So there are a whole host of things in which they are really going off in their own direction. And we wrote a 3-page letter. There were 5 of us involved in this. As I say, I ran them off at my expense, and we handed them out. And since I got a response from one person in the community, but that's okay, that's usual. I just want to know where we go after having gotten no response from either the board or the management company. Do we go to the city?
No, the city's not going to do anything. There is no agency for you to go to other than the court. So you have the choice of. Broward County is not interested. You have the choice of pursuing a recall. There is no state agency that oversees homeowners associations, so you're left with attempting a recall if you can get a majority of the homeowners to sign off on a recall agreement, or you need to hire an attorney and pursue the wrongdoing of the board through court action and litigation. Those are your basic options at this point.
So either, I just want to take a note, so either recall of the board.
Recall the board and replace them with people that will do things the way that you think it should be done. It takes a majority of all the homeowners to accomplish that, and you can get a form document on the Department of Business and Professional Regulation website, DBPR, and it's a fairly simple form. It's self-explanatory on what to do, but you need to collect one from every eligible voting person within the community so you can get at least a majority. You should probably have more than a majority just in case, and deliver it to the board either by a process server or by certified mail. And that would replace the board. Alternatively, you you would need to hire an independent attorney to address the concerns, which might get you further than your letters that you're sending on your own.
Right. Going back to the first thing, the recall, you get the what's the form?
It's a written recall agreement.
It's already written up?
It's already written up. You just have to fill in some blanks. There's instructions that are on it that are made to be relatively easy for owners to do on their own.
And where would
do
you
not
get
pre-mark
that?
it.
At Office Depot or something?
No, you get it at the website from the Department of Business and Professional Regulation.
Okay, just a website of Department of Business Regulation.
And Professional Regulation.
Oh, and professional
In the-
business and professional regulation.
Regulation. The Division of Condominiums will have a section with forms for the homeowner association and the recall forms. You should find them there.
Thank you,
Okay.
Judy. Let's go to our next call, Anita in Hollywood. Hi, Anita.
Yes, thank you so much. Hello, Robert.
Thanks for holding.
Hello.
It's quite all right. I live in a condo. The board a few years ago passed rules and regulations. One of them is that if I, the deeded owner, am not physically present in my apartment, I cannot have anyone else stay here for more than 2 weeks. In other words, I cannot ask a family member to come and watch my home. I can't ask a house sitter to come and water the plants. I am not allowed to have anyone stay here while I am not here for more than 2 weeks. This is not we do not allow rentals or leases. I'm not talking about rentals or leases. I'm talking about someone of my choosing that I am asking to watch my apartment or giving to stay in it for vacation while I'm away on an extended period. Should I be called out of town for more than 2 weeks? I want someone to watch my unit. Should I be in rehab or something? I want someone who can be here and visit me every day, an out-of-towner. And I asked, we have a new board this month, so I asked about this rule, and I asked for the minutes of the meeting at which they were passed. No one can locate the minutes. The president of the board contacted our condo attorney, told him I was a troublemaker because I asked. This is her first contact I've had with her. She was just elected or just volunteered in March. And now is telling the lawyer I'm looking for trouble because I asked the question. And no one can come up with an answer for me. Can a condo limit your guest staying while you're not here? That's number one. And what do I do? Nobody's being responsive to my questions. I also contacted the condo attorney, have not yet received any responses.
Well, in all likelihood, unless the board instructs the attorney to respond to you, the attorney will not. The rule that you're talking about, how long has it been in place?
I got an informal hard copy of these rules. They're dated January 2018. So I went on the Broward County website because all of our other documents are there, our other, I can't think of the name now, our other rules and regulations. This looked like an informal, printed, just handout. It wasn't notarized, it wasn't signed, and nothing. So I asked the question. I said, because of COVID, this has come to light, because people could not come down because of travel restrictions or health, and asked a relative to stay, or, you know what I mean, rather than have the apartment vacant all year. So I looked on the website, and when I couldn't find it registered with the county, as all of our other rules and regulations are, I asked the question, is this a legal document, or is it just an informal do's and don'ts? And, was this, in fact, the attorney himself said to the board president, give this resident a copy of the minutes. Well, nobody seems to find them. Can the board...
Well, the first thing you should be... the first thing you should be doing is making a written request for access to the official records of the association and actually go to them and go through them and find what's in the minutes at that time and anything else that might be there, if anything at all, relative to this rule. What happens at the end of the 2 weeks, or if somebody stays beyond that?
It's disallowed. I don't know, because the rule only says, it looks like an informal listing, you know, like suggestions of what you're supposed, don't leave the door open to the pool, you know, those kind of things. And this was in there. No one is allowed, unless the deeded owner is physically present, everyone is considered a guest after 2 weeks, and they're disallowed. That's all. Not allowed to have a guest more than 2 weeks if you are not there. And in fact, some of our owners, the owner of the residence is a corporation or it is a trust. So who's allowed? It's very vague. They cannot locate the minutes. I met one of our officers informally, and she said, we're all looking, we can't find the minutes. Okay. So I've made a written request.
Well, the board doesn't have the obligation to go through the records and find something for you and provide it to you. You have the right to access them and inspect them yourself. So if you're asking them to just find something and give it to you, they can ignore that if they choose without any violation of the statute. So again, that's the first thing that you might want to consider doing. Otherwise, you can make a certified mail written request for information about the passage of this rule that would provide whatever details the association has, a written inquiry, that they would have 30 days to provide you with a substantive response. And if they couldn't, then if there's litigation on the issue, and the association prevails, they would not be able to recover attorney's fees from you for the lack of response. But that creates a little paper trail for you. The other alternative, as with the last caller, you may have to hire an attorney to address it for you, as the board seems to not be as responsive to individuals as they would be to an attorney. Certainly their attorney.
The board has the power to restrict who I have in my legally owned apartment.
It is possible that the board could do that. It depends on your documents, if they have the ability to make such a rule. But they also have a procedure they have to follow in order to have an enforceable rule, which would include advance notice to everybody at least 14 days of the proposed rule prior to the meeting at which it's being adopted. And then they'd have to send out formal notice of the rule. And as you've indicated, other rules are recorded, so this should be recorded as well.
Okay, does that help?
A little. I'm really not sure how to proceed right now. The attorney said the board, in writing, that the board, yes, can pass rules without having them on the county website, without having them notarized or signed, but that I'm entitled to the minutes. And he said to the president in writing, give this homeowner the minutes. And I said, looking forward to receiving the minutes. No one can find them. That's one issue. That's an administrative issue. And then the substantive issue is, can a board tell me that my friend cannot use my apartment unless I'm here? Can a board tell me that I can't have a house sitter when I'm called out of town?
Yes.
They can,
Conceivably, yes. Depends on your documents and the circumstances in which it's done.
All right, this is the only document that addresses it. All of our other
Like
documents, nothing
they didn't
addresses
do it right. It sounds like they didn't do it right, and that means it would be unenforceable if you chose to ignore them.
Okay. Thank you so much.
Thanks, Anita. You know, we've had someone hold for a long time. We've got other people holding. Let's just take Steve from Sarasota. Hi, Steve.
Hello.
Thank you for holding.
Can you, excuse me? I'm holding?
No, thank you
go
for
ahead.
holding.
Okay.
What's your question,
In a
Steve?
condominium sub-association, can the board members of that sub-association change the officers or the directors at any time? And if so, what's the procedure?
For any association, generally speaking, the officers serve at the pleasure of the board. Then the board can change the officers at any meeting as long as it's on the agenda for that meeting that's posted at least 48 hours in advance. So if the board wants to reorganize, that's all that the notice would have to state for on the agenda item is reorganization, and then the board can adjust who the officers are at their pleasure.
Okay. And that was the question. Then it's answered.
Thank you.
Steve. Thanks
Thank
for
you.
listening.
Let's go to break. We come back. Oh, you got a lot of stuff coming up this month, don't you?
It's a busy month. That is true.
Yes. We're going to go break. We are here. Give everybody the phone number at your office in Pompano.
You can reach us at 800-974-0680. That would cover all three offices. 800-974-0680 or write to info@kbrlegal.com.
We're going to go to break. We'll be right back with more K. Bender Rimbaum.
K. Bender Rembam is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembam attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembam is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembam today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
And we are back. This is the Ask the Expert show. I'm host Steve-O. I'm here with one of the senior partners for K. Bender Rimbaum, Community Association attorneys. Huh?
Senior most.
Senior most, yes. We're here with Robert Kay. He's with us the first Thursday of every month. And boy, I tell you what, the phones are just ringing off the wall. But before we go to that, yeah, it always is with you guys. People love the show. We have one line open at 888-565-1470, especially if you're a board member. This is a great time. We've got the best in law firm in Florida, but you do so many classes and provide so many services to board members, and you have a whole calendar this month of things that you're going to be doing.
There's a lot going on, so we should jump right into that.
Yes.
Next week, April the 6th, on Tuesday, is the Palm Beach Expo. That's on site at the Palm Beach County Convention Center from 9 o'clock in the morning to 4:30 in the afternoon. We're in booth, looks like 23. We have 2 courses that we're giving: updating governing documents at 10 a.m. and the 2021 legal update at 2:45 p.m. Those are for the 2020 laws that were adopted. The session is obviously still in, so 2021 hasn't been done, but that's what they call it. And then on Wednesday, April 7th, we have a Zoom class, Association Insurance, the top 10 FAQs and concerns at 12 o'clock to 1 o'clock. That would be an informational panel discussion. Allison Hertz will be there from the firm with Brendan Lynch from Plastridge Insurance. And then on April 8th, on Thursday, top 10 common mix-ups and misperception of condos and HOAs, 11 o'clock to 12:30, also on Zoom with Allison Hertz and Sean Brown. And then on April the 9th, we have a condominium board member certification at 10 a.m. to 12 noon via Zoom with Andrew Black. There's going to be 2 continuing education credits involved in that case, or in that class. And April 13th is the Broward Expo, which will be at the Signature Grand in Davie from 9 o'clock until 4:30. We'll be at booth 200. Also the same 2 courses, updating governing documents at 10 o'clock and the 2020 legal update at 2:45. That's on April the 13th. April the 14th, Association Leadership is a Zoom course, Season 2, Episode 13, they call it, at 12 noon to 1 o'clock. That will be with Michael Bender, Jeff Rembaum, and the Castle Group in a panel discussion. Then on April the 20th, at 12 noon, a legislative update webinar with Michael Bender and Campbell Property Management on a panel discussion. And then on April the 27th, Navigating Federal Fair Housing Act, Assistance Animal or Pet, 12 noon to 1 p.m. via Zoom with 1 continuing education credit. Andrew Black will be the instructor in that. To find all of these, go to our website at kbrlegal.com. Click on the calendar and then all the events, and then you click on whichever one you want to register in advance. So busy month.
Wow, busy. Let's go to our phones. Joanne's been holding for a while in Lakeland. Hi, Joanne.
Hello, can you hear me?
We can hear you fine.
Oh, wonderful, wonderful. Well, thank you for taking my call, and I absolutely love you guys. I do take a lot of your classes to get educated. So
No, that's good.
I'm going to explain what I have been experiencing for 3 years on my HOA. I'll try to make it brief. So I purchased a little over 3 years ago, and a couple of board members used to completely harass me and yell in my window and scream for me, and I asked them to please stop. My office was at home. They wouldn't stop. I then put in a formal complaint. Within 2 days after that, I began to get bombarded with fake fines. They would just make things up to fine me. So then I learned the statute that you can't just fine somebody. You have to follow the law of a fining committee and the laws within that. They said, we don't have to listen to Florida law. We're going to fine you anyway. So all these fines, they kept adding and adding and adding and adding, and came to thousands of dollars. And I fixed whatever the problem they were accusing me of doing. Okay, so here we are. They offer me a fining committee. I say yes, they disappear. I hear nothing from them. A month and a half later, I get an opportunity. They say, we're going to give you an opportunity to go into mediation on this. My pro bono lawyer at the time said, just do it, Annette. Sounds like they might be trying to be reasonable. So I said, sure, I'll take it. Only had one choice one time. I said, sure, I'll take it. They hounded me, make sure I was coming. I said, yes, I'm coming, no problem. The night before, they cancel mediation. A month and a half, 2 months later, I'm walking out of my patio. An officer comes up, hands me a document. I sign it. Now I am summoned to court in front of a judge to pay these fines. In the meantime,
Is that what the lawsuit is about, the fines?
Okay. Go ahead.
Is the lawsuit about the unpaid fines, or is it about something else?
It's about one woman didn't like me. Jealous, if you want to know the truth. But the
No, I mean,
document was
what are
about
they suing you
unpaid
for,
fines.
money?
Correct.
Joanne, what
So
are they
it's a
suing
small
you for?
claim?
Go ahead. Yeah, yes, correct. It's about unpaid fines. That is correct.
Well, you do need the assistance of an attorney to get out of this mess, it sounds like.
So, correct. Okay, so I'm going to continue on. Yes. So I did go to the court. The judge, so then they added, so I'm going to continue on. So that wasn't enough for them. Then they began to say I'm trying to run them over with my car, that they hear me tell people I'm going to kill them and blow up the community. These are true statements. They would chase every one of my friends out of the community with phones. They would chase me around with cell phones. I've actually been surrounded by 5 of them, cornered with their cell phone in my face, calling me names. So finally, after 3 years of this, now this is still pending in the court. My attorney says, get out, move. I'm like, okay, so I moved. I bought a new house recently, under contract. Here I am, sell it. I bought a new home. Finally get an offer on my place. I go to close. Now they're holding back the sale of my home on the estoppel. Now, on the estoppel, they're saying, now, mind you, this has been 2.5 years with these fines, maybe 2. And it's supposed to see the judge in September, and due to COVID, be extended. So there's been no decision on these fines. It is to be seen in front of a judge. They want to continue. They're not letting it go. They want to continue and still bring this in front of a judge in September. So now they pushed me out of my home. Now they're not letting me sell. So they're saying I owe $30-something thousand in lawyer fees, plus, I don't know, round number $6,000 to $8,000 in fines. And they're holding up my estoppel. Now, I read up on every estoppel statute. This is not a concluded violation. This is a hearsay. So there's my story. That's it pretty much.
Well,
so there's a whole lot of between there, but that pretty much covers it.
Your situation's a little beyond the scope of a call-in radio show. You need an attorney
I'm sure it is.
who is well-versed in this area of the law, because it sounds like there are many avenues of attack of what's happened to you. It sounds like they haven't followed proper statutory procedure. Depending on your governing documents, in all likelihood, these fines cannot be a lien against your property. The legal fees have not been determined at this point, so that can't. You've got a lot of issues. You have claims for tortious interference with your contractual right to sell your property. It's possible that something can be done in the court to sever these claims from the property so that you can complete the sale, but you're going to need an attorney, local attorney, who understands this area of the law and can assist you in that. But unfortunately, for the purposes of this radio show, I don't think we can offer you a whole lot more on this.
No, that's plenty. That's plenty. That in itself is enough. I feel very confident that what they're doing is wrong. I do have an attorney. It's not his field, so I'm going for an attorney that this is their specialty. It's gone to a level that is beyond. Yeah. So
maybe give her the phone number of the office, Robert.
We're not in Lakeland, and she needs somebody up there.
Oh, she's in Lakeland.
No, I did call you guys for representation, but I understand that you only represent the association. You don't represent residents.
Primarily, that is correct. Yes.
Correct. I did call you for representation, so I did do that initially. So, at any rate, I do appreciate your time and solidifying.
Thank you, Joanne.
My situation. Yeah.
Sorry for the problems you're facing.
So we got several
else?
lines open now, and you can give us a call here at 888-565-1470. You know, gosh, Robert, we had 5 or 6 emails all about cigarette smoking. Some of them were saying that they think people are smoking in their condos, that it's going through the walls. Some people said they're out on their porch. And what is the ruling when it comes to cigarette smoking? Does it matter if it's a condo or HOA?
There is no particular ruling. It depends on the documents for the community and the situation that's involved, and whether or not it's inside, outside. There's a lot of factors that come into play on this issue. I mean, it's conceivable that the association may be able to restrict cigarette smoking within and cigar smoking within condominiums or HOAs, but the documents have to be clear on the topic. If there's a nuisance situation where one unit owner's smoke is affecting another unit owner, the statute for both condominiums and HOAs allow individuals to pursue legal action on their own. It's not necessarily an association issue when it's just two neighbors having a dispute with each other. Even if there's something in the documents, it might be something that is more appropriate for them to be addressing between themselves as opposed to the association being involved. In some instances, the association's not a private police force for one or the other, or in a position to decide which one of them is right when it's just two unit owners going at each other. That's why it's often best to let them sort it out themselves. And there is the ability for them to recover attorney's fees and costs if they pursue it on their own. Conceivably, though, it could be an issue in the documents that can be addressed. Usually, the board will have rules addressing smoking on the common areas, possibly even on balconies, but within the unit is something that would have to be in the declaration of condominium or declaration of covenants, clearly restricting the ability to do that within the unit in order for the association to be able to do any enforcement on it.
Okay. To Vincent in Hollywood. Hello, Vincent.
Hi, how you doing?
Good.
Who am I speaking to?
You're speaking to Steve O, and you're speaking to attorney Robert Kay.
Oh, okay, good. Because I'm watching what I thought was live, but evidently I'm not.
Okay, good.
Situation is, I'm a board member, and I've been on the board for almost 20 years, and I've covered every facet of being on the board. I was a licensed CAM for many years. The situation is now, I'm older, and I don't have the ability to be a board president or anything like that. But the current board president is cutting me out several other board members as well, of keeping us informed. I've told them I want to be involved in any of the contractors come in so I can keep them informed of what's going on, where things are in the building, because I have privy to all that information. So, and they've recently hired a new property manager who thinks that the board doesn't have the right to screen, and the board doesn't have the right to have a contractors agreement done by board members.
So what is your question?
Well, I'm just wondering, can the board president do that? Can she prevent people? She doesn't even allow anybody who works in the building to talk to me. Seriously, they're forbidden to talk to me on threat of being fired.
How many board members are there?
9.
9?
Yes.
And I assume that at least 5 of the board members, including the president, are supportive of what she's doing?
No. There's
well, are at least 5 opposed to what she's doing?
It's just that it's totally cut out. We had a
Are there?
screening committee or a orientation committee that was doing this for years, and I was part of it. Now they just said we don't have them anymore. We had a contractor's agreement form to make sure all the rules and licensing and insurance and so forth was in place, had it checked out by an attorney. It was a good form, and all of a sudden we're not allowed to use that anymore. That's according to the new management.
So the issues that you've described are basically within the purview of the board as a whole to address. And a majority of the board decides on these issues. If the board decides that individual members of the board are not to have contact with contractors or not to have contact with other aspects of the operation other than attending board meetings and voting on board issues, that's legally acceptable. It's a political issue. If you want to be involved and the president doesn't want you involved, but a majority of the board agrees you should be involved, the majority of the board can overrule the president on this or remove the president and replace her with somebody else to be the president. So what you've described is a political issue internally to your community, and you need to be working with the other board members to achieve the goal that you desire.
Can I put that on an agenda for the next board meeting?
Well, I don't know that you have the authority to put anything on the agenda. It would be up to whoever creates the agenda to do that. You probably would be best in addressing among your fellow board members one-on-one to get to the consensus that you need to do behind the scenes before there is a board meeting. You can request it to be on the agenda, but if they don't put it on, you'd have difficulty forcing it at the meeting. If there's something that's not on the agenda that the board members want, it would take a majority plus one of the board members to add it to the agenda, and then it would have to be an agenda item at the subsequent meeting to be ratified.
Okay. I thank you for your time.
Thank you, Vincent.
You're welcome. Thank you for listening.
I thank you for your time, and I will
Okay.
put it on the agenda.
All right, good luck.
Wow.
Thank you very much.
So I want to get to some of these emails. I've been holding them for a long time. Kelly and Boca wanted to know, does everyone in the House have to be approved by the board?
That's going to be a document issue, depending on what the board has the approval rights on. So you have to check into your documents to see whether or not all occupants have to receive approval or just the people who are the owners or the tenants, or exactly what the situation is.
Cheryl from Boynton, she said, I'm on a board of 5 members. 2 are certified and the others aren't. How do we get them or push them to get certified?
Well, as we've discussed on some prior shows, the statutes provide that board members need to be certified in order to validly continue in their position. And there's 2 ways to obtain that certification. One would be to attend an appropriately authorized board certification course, which is like what we offer. And the other way is to obtain a form from the Department of Business and Professional Regulation website that says that the board member has the governing documents and agrees to abide by them, and sign that form and put that in the records. So if the board member does not want to take a course, they can simply sign the form. Board member has to do this within 90 days of being elected or up to 9 months before being elected for it to be effective, and then it will be effective for up to 5 consecutive years, so long as the board membership continues for those 5 years uninterrupted.
Phone number here is 888-565-1037. 1470. 888-565-1470 if you have a question for Robert. David in Hollywood says he lives in a 55 and over community. He said, aren't we supposed to have a unit owner roster with current IDs on file for all the residents? I'm getting a lot of pushback on that. What should I do? That's the first time I've heard of a unit owner roster.
Well, what it is actually required is a census be taken every 2 years and kept current on a biannual basis that identifies the individual who's over 55 that's occupying the particular unit. So as long as you have at least 80% of the units represented in that capacity, you'll qualify for the exemption under the Fair Housing Act to allow you to be family or to be housing for older persons and keep children under the age of 18 from permanently residing within the community. If you fall below that 80% number, then you're subject to challenge and losing that exemption status. There had been a period in Florida where the state was having qualified communities register in Tallahassee, but that was taken out of the statute relatively recently, and it was not mandatory, but it was evidence of compliance with the exemption requirements. But the census is a requirement under the guidelines of the federal government, and so that should be maintained in the association records, and that's in case of a challenge, you'll be able to prove that you qualify.
Okay. Mona in Palm Beach Gardens wants to know, do you always have to have an organizational meeting?
Well, an organizational meeting is after the election of a new board when they establish the officers for the coming year. It can be done at any point. There's no specific requirement that it be a separate meeting unless your bylaws so specify, but you can have it follow immediately from the annual meeting so that you can do it all the same night, or many documents provide if it's done within a certain period of time following the annual meeting, such as 10 days, no additional notice is going to be required to the community. If it goes beyond that, then regular notice requirements would apply. But unless you're just keeping the officers the same, then an organizational meeting would serve that purpose.
Okay. You can, if you have a question for Robert concerning community association, whether it's HOA or condo, you can give us a call here at 888-565-1470, 888-565-1470. Can the board change the hours of the amenities, Robert?
Again, that's going to be a documentary specific type issue as to whether that falls within the scope of the board's authority. Most likely it does, but when the board does establish these hours, it's going to have to be reasonable in what it does, and that's sometimes subjective as to what's reasonable and what isn't under the circumstances. So I'm going to say in general terms, yes, the board would have that authority, because if not the board, who would set that?
Okay. Here's a board member said that two people applied to rent. One person didn't agree to the background search, so we did not let him in. He always comes around the woman's condo who was approved. Do we have to let him in?
Well, anybody who resides in a building has a right to have guests come and visit them. So yes, they have to let him in unless they have a bona fide basis to not let him in. Now, if they think that he's occupying the unit without the approval, then they would take steps of enforcing their approval entitlement under their documents, and they may have to, if it's a condominium, file for arbitration, or if it's a homeowner association, pursue it in the courts. But it's not recommended to block the door or keep somebody out of the building through a self-help remedy.
Okay, let's go to Joanne in Boca. Hi, Joanne.
Hi, how are you? I'm new to the board. I'm the president of the board, and I've been getting some flack about are you allowed to display the code of ethics and conduct in the lobby? I'm being told that that's illegal to do that. We have 3 buildings, and in each lobby there it's displayed. So I just need to know, is this a legal issue or not?
When you say code of ethics, what do you mean?
Well, what we do is we have a code of ethics and conduct, and in it, like for instance, it'll just say, I'll give you there's like 15 items to it, and one of the items is no yelling, no swearing, and no screaming at the board, and that's one of them. And I don't know what to do with this code of ethics, to be honest with you.
You're talking about rules governing the behavior of the residents of the building, not ethics of how the board
and the board members.
Well, there's nothing in the law one way or the other on this issue, so it's not illegal to place it, and it's not mandatory. So if the board wants to display it in the building, the board can do so.
Okay, thank you very much.
Okay,
Thanks, Joanne.
Welcome to the life of a president.
Yes.
Thank you. It's challenging. Thank you.
Let's see if we can sneak one more call in here. Donna? You're up.
I was wondering if you had any tips about insurance and also about the 40-year inspection that's coming up on us now. And this is a whole new board. We don't know what we're doing. And I was wondering if you had some tips that we could use.
Well, when you talk about tips for insurance, what do you mean?
Well, like how to save money. And, a lot they're requesting roofs. We have 9 buildings and 2 need to be replaced. And, and they're going up 20%. And, we're just trying to do the best we can. We do have money in reserves. That's not a problem for us. But and then with the 40-year coming up, we're worried about that, what we have to do, and trying to save some money for the association.
Well, you may be aware that the insurance industry is talking about increases in premiums across the board, and a lot of carriers are refusing to write insurance. So when you have less people that are providing coverage, the typical result of that will be the premium costs will go up. So it's difficult to get around that. Your best bet on the insurance is get with an experienced insurance agent in the field of community associations so they can shop the various opportunities for you. You usually have a very narrow window of time prior to the expiration of your current policy before any of them will offer you anything. So the timing is fairly critical on that, but your insurance agent should be working and keeping abreast of the market for you all the time and speaking to you on a regular basis. Now, the issue, what was the other issue?
Okay, the 40-year, all these condos, there's a lot of them here and a lot of buildings, and we're all going to be going through the same thing because they were built at the same time. Do you have tips to suggest what to do to help with the 40-year, expenses? Well, what we should be doing?
The best approach to take is to bring in an engineer as quickly or as much in advance as possible of the 40-year date to give you an overview of what's going to be necessary in your building so you can start to plan for the expenses that you may be faced with and not have a short window of time to take care of all the things that are going to be necessary.
Okay, so do things
there may be on our website a little seminar on the 40-year inspection. So if you go to our website, kbrlegal.com, and look to prior webinars, we did one last summer on the 40-year inspection, and that should be able to give you a lot of information on that.
There's our music. And
okay, thank you very much. I appreciate your help.
Thanks for calling.
Thanks for listening.
Okay.
Give Bender Rimbaum a call tomorrow morning at their office. This is why you need somebody.
We're closed tomorrow.
Oh, that's right, tomorrow. That's right. I'll have to call Monday. Hey, thanks so much, everybody. Give it their phone number one more time.
800-974-0680.
Thank everybody for calling in today. You're great, Robert. Thank you so much. We'll see you again next month. Happy Easter, everybody.
Stay safe.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on